Hi, Tony DeWitt here, Missouri Appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to take a look at the closing arguments by the state and by the defense in the Jesse Kurczewski murder trial. That's the one that involves poisoning the victim with tetrahydrozoline, eye drops, essentially. And it's an interesting case from a number of perspectives. And it's also, I think, a made-for-TV movie just waiting to happen because it has all of the things that really make a good drama. You know, a kind of a terrible event that happens. This lady's murdered, and then before she's murdered, most of her money is stolen, and then after she's murdered, the rest of her money is stolen. It's a fairly pathetic. If the state's case is correct, and I'm not assuming that at this point because the jury hasn't spoken, but if the state is correct that this all occurred in the way that they say that it occurred, this is an awful situation, and I felt bad for the lady who was killed. I don't feel bad for the person who's on trial. This is an interesting study in contrasts also between the prosecutors and the defense attorney. Now, the prosecutors, at least to me, appear to be straight up, taking the lead, direct examinations that are well thought out, and cross-examinations that are well thought out. I have witnessed a lot of parts of this trial. I haven't watched it from beginning to end. I never watch a trial from beginning to end because I just don't have the time. I work during the day. So when we look at this, we'll be looking at the first closing argument, obviously, is done by the state. And the state goes first because it has the burden of proof, and it goes last because it has the burden of proof. In this particular instance, what we have is a prosecutor who gets up and starts laying out her theme. The defense has a little bit different style. Somebody pointed out that she looks kind of grandmotherly and, appears to be a little confused at times, but somebody thinks that at least one of the commenters have said that they thought that was an act. And it may very well be that she is a shark in dolphin's clothing. And yeah, I know the proper metaphor is wolf in sheep's clothing, but since lawyers are often referred to as sharks, I just thought dolphin was better. Anyway, I don't think the Columbo routine works out for her. It worked out for Columbo because it was TV. It wasn't real. And that's what made it funny and made it, somewhat credible. Now, the Columbo technique can work, and I've seen it work in various interrogations. But in this situation, when you're the defense counsel, being Columbo doesn't really help you much.
This is my opportunity to argue the case. The evidence is in, and soon you'll be asked to deliberate whether we've met our burden in this case on all three counts. All three counts follow this theme of murder, greed, and lies.
Now, you see what she did there? She talked about the theme of the case, murder, greed, and lies. And that's because there was a murder, there was theft, and then there were lies and lots of different stories told in order to sort of prevent discovery of what actually happened. Unfortunately for Ms. Kurczewski, it didn't work out that way.
That my co-counsel introduced during opening statements. And that's how we'll discuss it here this morning, starting with count 1, the first-degree intentional homicide of Lynn Hernan, and moving into the greed. Count 2 being the theft while Ms. Hernan was alive, and count 3 being the theft from Ms. Hernan's estate.
Okay, now again, this is a very logical, orderly, well-thought-out plan for how you discuss the elements and the evidence in the case. They're using PowerPoint, and it is possible to have death by PowerPoint. I realize that. But I think that she is doing a very good job here of setting the stage for where this case is going to go.
When we talk about count 1, the judge just read you the elements. Ladies and gentlemen, we submit to you that in this case, Ms. Kurczewski caused Lynn Hernan's death with the intent to kill her. You heard moments ago that it's not necessary that every fact be proven directly by a witness or an exhibit, and that in fact circumstantial evidence can be just as powerful. Whether it's direct or circumstantial evidence, the only thing that matters is whether it satisfies you beyond a reasonable doubt. The circumstances in this case are significant. The cause of death in this matter, as determined by Dr. Bedritsky, is poisoning. Tetrahydrozoline is a poison. Dr. Bedritsky talked to you about her job. It is her job for Waukesha County to make determinations on cause and manner of death.
Okay, so it's obvious here that she's working right into the evidence, and she's going to lay out in an orderly fashion all of the reasons why this person should be convicted. I think this is an excellent approach, and I think it's very direct. I would give her an A+. I've been through the entire closing argument here, and I think she's done a pretty good job. But now I want to contrast that with the closing argument of the defense counsel, and I want you to notice the significant difference in the approach that's taken by both by the state and then by the defense.
Ladies and gentlemen, this case is not a homicide. The state has not proven a first-degree intentional homicide. It's what everyone concluded on October 3rd, 2018. It was a suicide. And everyone who came to the scene on that day concluded it was a suicide. And they concluded it for a lot of reasons, including what you saw, which is a whole boatload of prescriptions that were laying around. Lynn was hoarded pills, and they were everywhere. Pills that were no longer prescribed to her. And the pills were found in her system. She took all those pills. And also, when the medical examiner did the evaluation of the stomach contents, pills were in there. It's what is called a polydrug overdose. When somebody takes too many pills, the combination together can create exactly what happened here. That is Lynn's death.
Okay, now I think this is a pretty interesting approach because, you're giving the jury an alternative explanation for what happened. But the jury likely remembers that the reason everybody suspected that it was suicide is because it was staged that way. And all of the witnesses who knew this lady reasonably well, they all testified she wasn't suicidal. She wasn't, depressed. She was doing quite well until Jesse Kurczewski allegedly ripped her off and then killed her. So one of the things you have to be careful about when you are a defense counsel and you're putting up evidence that conflicts with the prosecution is you have to make certain that it's bulletproofed, that you can explain why it is that nobody thought that she was depressed.
And Dr. Thomas, when she was here, she said there was strong evidence. Let me see what I've got. This is the prescription medications in the living room. And I don't want to forget about what was at the scene. Remember, people who were there that day weren't looking for eye drops. That wasn't on their mind. So the suggestion that there were no eye drops is not true. It's not proven by a fact. It's just an opinion. And when the people came in and testified, law enforcement, they agreed with us that they weren't looking for them. And Dr. B.
And why would you be looking for them? Why would you be looking for eye drops when a woman is dead? You would only be looking for eye drops if you knew that this woman had been poisoned with eye drops. So it doesn't make sense to attack in that way. But this lady has a hard job, and she's doing the best she can with the limited facts that she has. You know, we often say that you can't file a timely motion to change the facts. You just have to argue the facts and put a different spin on them, which I think is what she's trying to do here.
Agreed 100% eventually that there was a bottle of eye drops, albeit not the ones with tetrahydrozoline, the ones that she would use in her actual eyes, on the table next to her. But if you're...
Okay, now that right there is an unforced error. Did you hear what she said? She said not the ones that she actually used. So if Lynn Hernan did not actually use Visine and tetrahydrozoline, then why would she be ingesting it? So we have a real problem here for the defense in Kurczewski's statements about how this all happened. And to get there, I want to just flip back for a second to the prosecution's opening statement, where they go through some of the video evidence from her interrogation. And I think this is going to be the part that this particular attorney has a hard time dealing with. Now, this next part is from the prosecutor's closing, and I'm going to hear a little bit more about the suicide and then the different stories.
Lies are very tricky to keep track of. The truth is very simple. And in this case, we've shown that Ms. Kurczewski lies when it will benefit her. When she's in hot water, she lies. Ms. Kurczewski compartmentalizes people in her life to keep them all from the truth of what's actually happening. And the intent behind this is to mislead them. And the motive is her own personal gain. Throughout this case, the question of whether Ms. Hernan was suicidal changes multiple times. On day one, on October 3rd of 2018, Ms. Kurczewski is not telling any EMS worker or deputy, oh my gosh, she's been drinking Visine, she had a gun once, she's been trying to kill herself. I can't believe this happened. No, she's asked, point blank, was Ms. Hernan suicidal? And the answer is yes and no. But after this date, what do we know about Ms. Kurczewski? She's very interested in what the medical examiner knows and what the sheriff's department knows, because she's calling. What's in the toxicology? Do we have the toxicology back yet? Until they finally tell her, we can't talk to you anymore.
Good idea.
So she comes in and talks to detectives. This entire discussion on Ms. Kurczewski's point is to mislead them. She's not going to reveal she poisoned Ms. Hernan with tetrahydrozoline because she doesn't know they found it yet. She doesn't know that anybody knows what she did yet. So she's not going to bring it up, just like she didn't bring it up on the day it happened.
See that timeline she's using? That's a good tool.
Maybe they won't find it. Then we have the star. July 9th of 2019, when Ms. Kurczewski is finally told this.
I'll be honest, there's been 3 times that she said, I want to give up.
Yeah.
I don't want to do this anymore. And she always said, the day when it comes, I want your help. The day when it comes, I want your help. I said, I'm not helping you do anything. When it comes to pills or messing around with anything, I'm not looking for trouble. I'm not trying to get in trouble.
When she
She's
said,
a
like
full-grown adult.
like our doctor from work.
So that's a pretty different story than that. As soon as she knows the gig's up, well, okay, 3 times she said she wanted to give up. Ms. Kurczewski is constantly considering the new information that she's getting and altering her story in a way that benefits her. The next day,
That's what she did.
She wants to talk to law enforcement. I want you to remember that. All of these interviews are because Ms. Kurczewski thought about things overnight and wanted to give more information the next day. So the next day, the question of was Lynn suicidal changes again.
Because she was trying to find an easy way out.
She did
She
to
did
kill
the
herself.
pills first numerous times. That wasn't working.
So she was trying to kill herself
Yeah.
by drinking Visine and vodka.
She also bought a gun offline
When
that
was
I disposed of for before she died too.
When? How long?
Oh, 2 months.
I have that hard to believe. You can't buy a gun online.
I submit to you, ladies and gentlemen, that Ms. Kurczewski knew, well, they found it in the toxicology now. I have to say she was suicidal and that she drank it on her own to keep myself out of trouble. The intent behind all of this is to mislead, and the motive is to keep herself out of trouble.
What you have here is a prosecutor who is laying out her case very, very effectively on in her closing argument. And essentially, when the defense gets an opportunity to take on this argument, their approach is to nitpick.
When you get a second opinion on a cause of death and a manner of death, what the second pathologist does is really take a look with fresh eyes at everything. And what she looked at were the same things that Dr. B looked at. No, she didn't have the body in front of her, but there's nothing about having the physical body in front of her, of Dr. B, that led to any conclusion that Lynn died of tetrahydrozoline poisoning.
But you have to remember, this is a person who's been hired by the defense to offer that opinion. So to a certain extent, there is some discounting of that opinion.
Calling the medical examiner for answers. So, yeah, Jessie knew that Lynn would take THC, take Visine, drink it, but she doesn't know how she died that day. Looked like a suicide with pills from a person who was unhappy.
But
She
again,
kept calling the medical examiner.
the people who
and
knew her
only
didn't tell that.
Medical examiner stopped talking to her, or their office, it wasn't because they said we don't want to talk to her anymore. It's because the detective put a hold on it and said, don't talk to anybody anymore.
Of
That's
course,
the
for the
reason
reasons that the state pointed out.
And Gary Verdon was here in court. He told you, didn't he, that and that was a friend of Jenny's. Sure, it's a friend. But he saw Visine from the get-go. He saw it in her garbage cans on the occasions that he was at her house. And you know what? If he was going to lie to you, he's under oath like everyone else. He's an honest person on the witness stand. I didn't detect anything from him that struck
He's going to draw an
me as
objection.
dishonest.
Objection.
Yeah,
If he's
vouching,
going
you
to
can't
lie-
do that. She knows better than that.
Why not go all the way and say, hey, I saw her drinking Visine.
Well, maybe because he doesn't want to go to
Wanted
jail for
make up a
perjury.
story to help somebody, that's what you'd say.
No, it isn't. Not if you were smart. You can see her nitpicking individual pieces of the evidence and trying very hard to avoid the overwhelming force of all of the evidence. Now, that's her job. That's exactly what she should be doing, or at least trying to avoid that. That's exactly what she should be doing. She's doing an admirable job of it. This whole thing with the hands when she's talking is driving me nuts because I don't think it adds anything to it, and it's just distracting. But other than her personal style, which is a little off-putting, she's doing, a B-plus job of defending this case, trying to point out where there might be reasonable doubt. The problem for her, and I think for Kurczewski, is that when you weigh all the evidence in toto, what you have here, at least as summarized by the state in its closing argument, is a pretty compelling case. Now, the state not only gets to go first, but they get to go last, and the last little part of their closing argument was especially powerful. Now let's watch a little bit of the state's rebuttal on closing.
Thank you. While you take those down, we'll just stand for a little bit. The state does have an opportunity to offer brief rebuttal. So we'll, Nikolai, when you're ready.
Thank you, Judge. Ladies and gentlemen, because we have the burden of proof, I get to address you one more time. And the video you were left with was Jesse Kurczewski asking the detective, why in the world would I have any reason to kill Lynn Hernan if all of her money is gone? I submit to you there was 87,000 reasons to do that, because that's the amount of theft that Ms. Kurczewski has taken from the estate in this case. This is supposed to be a search for the truth. And what has happened is that it has become a full-blown attack on Lynn Hernan. I want you to think about some of the things that you've heard said about this woman. And then ask yourself, why does that matter? She's an alcoholic. She's an angry drunk. There's bottles of alcohol at the house. The intent is to mislead you. Lynn Hernan had no ethanol on board at the time of her death.
Good point.
Lynn Hernan was not a bad person. She was a complainer. She smoked 60 cigarettes a day. She needs to exercise. She was 251 pounds at death and bad at spelling. Why do those things matter to you? Why were those things presented to you over and over and over again in this case? I submit to you, the intent was to mislead you. The intent was to shift your focus from the truth, which is what you are to be searching for.
That's an excellent strategy.
If Lynn Hernan taking her own life was such a reasonable hypothesis, consistent with the defendant's innocence, then why did she have to lie about it? I submit to you, ladies and gentlemen, that the reason that everyone at the scene thought this was a suicide is because that was exactly Ms. Kurczewski's intent that day.
You have the prosecutor going back point by point and knocking down all of these sort of straw men that the defense has put up. But again, that is the defendant's job. The defense job is to get up there and challenge the state's evidence, offer alternate explanations for it. The problem is, if you're going to offer alternate explanations, they have to be credible and they have to have been consistent from beginning to end. And here, as she pointed out elsewhere in her closing arguments, Ms. Kurczewski's story has varied widely from the beginning, saying that she never was suicidal, all the way up to the point where she was clearly suicidal and drinking 6 bottles of Visine. This is always a problem for the defense, so they do what they can to knock some of that down. Now, I want to show you one additional thing here. The judge has received a question from the jury, and it has to do with the definitions in the jury instructions for cause. And one of the terms that they use is that it was practically certain that she caused the death of this individual. So the jury has sent out a request to clarify the term practically certain.
Worked with the parties at sidebar. It's not technically a sidebar. I had Madam Reporter working on getting me what I said about the first question that we were addressing. And that was, may we please have a definition and elaboration on the term, quote, practically certain, listed in the second element under count 1. My response, based upon our discussion earlier and confirmed by Michelle, the court reporter, I tweaked it just ever so slightly, but I thought this read a little better, is as follows. The jury must rely upon the definitions provided in the jury instructions. No further definition or explanation of, quote, practically certain will be provided.
Okay, so then she goes off to a couple of verdict forms. They made some tweaks to the verdict forms. What's interesting here is that they are clearly deliberating the first count, which is the murder count, and they want to know basically what practically certain means. This is a very careful jury. They want to make sure that they get this right, and the defense has said this is a suicide, and the state has said this is a murder to cover up a financial crime. And so now they have to decide if the evidence, all of it taken together, meets the threshold of beyond a reasonable doubt to establish that it is practically certain that she caused Lynn Hernan's death. That, I think, if I was on the prosecution side, would make me worry a little bit. We'll have to see how this all comes out. Anyway, that's what I have for you today. Thank you so much for watching. If you have the opportunity today, I hope that you will do something nice for someone today and catch me down here. Oh, and if you have any questions or comments, in the comments below, or you can email me if you have anything you'd like me to discuss. I really appreciate all the good suggestions I've been getting, so thank you for that. And have a great day. Catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.